Mastering company registration process. Companies are shackled by rigid amendment rules for their articles of association. Why must its governing documents be updated in a specific manner when a company needs to amend its articles of association, and what is the precise process that its directors or shareholders must follow to accomplish this task? When a company needs to amend its articles of association, its governing documents must be updated in a specific manner to ensure compliance with legal requirements and maintain operational excellence. The Articles of Association, also known as the Articles of Incorporation or Memorandum and Articles of Association, are a vital part of a company's constitution, outlining the rules and procedures for its internal governance and management. To update the governing documents in a specific manner, the company's directors or shareholders must follow a precise process, which involves several steps. First, they must identify the specific provisions in the Articles of Association that require amendment. This may involve reviewing the company's current operations, assessing its future goals and objectives, and determining whether the existing Articles of Association align with these goals. Once the necessary amendments have been identified, the directors or shareholders must convene a meeting to discuss and approve the proposed changes. This meeting may be a board meeting, annual general meeting, AGM, or extraordinary general meeting, EGM, depending on the nature of the amendments and the company's internal governance structure. At the meeting, the directors or shareholders must pass a special resolution, which requires a majority vote of at least 75% of the members entitled to vote. The special resolution must be specifically worded to amendments the Articles of Association, and it must comply with the relevant legal requirements, such as the Companies Act. After the special resolution has been passed, the company must prepare an updated version of the Articles of Association, incorporating the approved amendments. This updated version must be dated and signed by the company's authorized representatives, such as the company secretary or a director. The company must then submit the updated Articles of Association to the relevant regulatory authorities, such as the company's registry, within the prescribed timeframe, usually 15 days after the passing of the special resolution. The submission must be accompanied by the requisite filing fee and supporting documentation, including the special resolution, the minutes of the meeting, and any other relevant documents. Once the updated Articles of Association have been submitted to the regulatory authorities, the company must wait for approval and certification. This may involve a review of the updated documents to ensure compliance with legal requirements and internal consistency. Upon approval, the regulatory authorities will issue a certified copy of the updated Articles of Association, which will serve as prima facie evidence of the company's amended constitution. Throughout the process, it is essential for the company's directors or shareholders to maintain accurate and detailed records of all meetings, resolutions, and filings, as well as to update the company's internal records and registers accordingly. This will ensure that the company's operational excellence is maintained, and its governing documents are kept up to date and compliant with legal requirements. In conclusion, updating a company's governing documents when amending its Articles of Association requires a specific and precise process, involving the identification of necessary amendments, the passage of a special resolution, the preparation of updated documents, submission to regulatory authorities, and approval and certification. By following this process, companies can ensure that their governing documents are kept up to date, and their internal governance and management structures remain effective and compliant with legal requirements.